clear.
Loud and clear.
Now we turn to the Supreme Court ruling this morning. It issued a landmark decision in the case of Janus versus AFSCME, ruling 5-4 that labor unions may not collect, quote, agency or fair share fees from workers who do not want to join the union in a union shop, but who benefit from the collective bargaining agreement. The court had ruled 41 years ago that unions could charge only for services that non-union members benefited from, such as negotiating collective bargaining and grievance procedures. The ruling is seen as a major blow to organized labor. We're joined from Massachusetts by Peter Knowlton. He is the president of the United Electrical, Radio, and Machine Workers of America. And we're joined from Los Angeles by Jeff Bigelow. He's an official with AFSCME, the American Federation of State, County, and Municipal Employees. And earlier, Jeff was in Springfield, Illinois, so knows directly about the Janus case. Welcome, Peter and Jeff.
Thank you.
Thank you.
Peter Knowlton, let's start with you. This is not a huge surprise, but it is a huge setback for organized labor and for working people in the United States. Just what's your initial take?
So I think our initial take on this is, it is, as you said, it's a massive decision against the rights of union workers in the United States in the public sector. And we do see it as part of the wholesale assault on labor unions and on workers' rights that's been going on, well, as long as I've been around in the labor movement. So it's been at least for the last 4 or 5 decades. And obviously it precedes that as well. But it's just a continuous assault on the rights of workers to be able to determine their own destiny and how it is that they want to be able to fund their organizations. I think one of the things that gets lost that for us is a fundamental precept of the collective bargaining agreements and of what is called agency fees or even union dues is that they are all part of collective bargaining agreements that are voted on by a majority of the workers at vote. So to a large degree, a collective bargaining agreement is simply a written expression of what the majority of workers in a particular workplace want. And for the U.S. Supreme Court to now say, oh, well, you can have this or this, but you can't do that, for us is inherently an infringement on our democratic rights as workers to be able to govern our workplaces.
Jeff Bigelow, a quick, just technical or legal question. Again, both of you know, and we don't really know in detail about this, but if there's does this have the capacity to overturn existing collective bargaining contracts that recognize a place as a closed shop?
Yes, it will. It won't overturn the entire contracts, but it'll certainly overturn those portions of the contract that provide for fair share provisions. It may overturn portions of contracts that have to do with what's called maintenance of membership, that have to do with the stability of the union and stability of the membership. So it will do that, and it's and these are provisions, as the union leaders said, that were not only voted on when the contracts were approved, but in the case of fair share, or what's also called agency fee, that's directly attacked by this decision, the ability to have agency fee, the ability to have fair share, is often voted on separately in order to get that. So it's an overturning of what the votes that have already been taken. The majority that has already spoken on this is definitely a right-wing billionaire initiative to push back labor.
Peter Knowlton, I was curious as to what unions can do now to maintain the strength that they already have in what have traditionally been union states. This decision, I think, is going to affect mostly states that have long been supportive of unions, Rust Belt states, New England states. What can unions do to at least try to maintain some of the strength and authority that they have in those places?
So for our own union, and we are very much of a bottom-up driven union where our locals are the primary source of our strength and our wisdom. And so for us, it is for the membership and the leadership in different locals to develop very deep relations with its members and the people that it represents. And that now you're going to be on a landscape to a large degree where dues are considered quote unquote voluntary. So the union is really going to have to show its mettle to the members that it represents and be able to be very responsive to their particular needs. We represent a lot of public sector workers already, as does the brother from AFSCME, in right-to-work states already, right? So we know intuitively what it is that it takes in order to build a strong union when you're working in that particular environment. And it involves making sure that the members are completely aware, they're informed, that they're actively engaged in every aspect of the union, and that they run every aspect of the union. And you've got to give people a reason to want to be able to put money into an organization that actively represents them. So if you are actively engaged, for instance, in concessionary bargaining or two tiers, or appear to be just simply going along to get along with the employer, it's very possible that you might lose membership over that. So you're going to need to really develop some very strong educational programs, some strong fight-back programs to really be a very, very strong advocate for the members that you represent in that particular workplace. This is a really bad decision, but in some respects, it's going to force the public sector unions to operate a little bit differently, knowing that their ability to collect whatever income they get from dues dollars is not guaranteed from one year to the next.
Interesting. That's the voice of Peter Knowlton. We're talking to Peter from Massachusetts. He's the president of the United Electrical Workers. We're also speaking with Jeff Bigelow, who works for AFSCME. I want to come back to that theme, Jeff, about what it will mean for the labor movement. Could it possibly be one of those situations where the unintended consequences of this vicious anti-labor decision by the Supreme Court will, in fact, push the unions to take a more aggressive, more militant, more fight-back sort of orientation on the ground? Let's come back to that, but just help the audience explain who Janus is and what the genesis is of this case.
Okay, Mark Janus is a child support worker in Springfield, Illinois, who's part of a union, AFSCME Council 31. His logo is AFSCME Local 2600, and he's a state worker because that function is a state function in Illinois. And over the years, the state of Illinois, both under Democratic and Republican administrations, has tried to make moves to privatize, to have massive layoffs, to undercut rights, to not pay people properly, to try to do away with pensions, to try to increase health costs. And the only thing that stood in the way of that has been a very strong AFSCME union there, a very strong activist AFSCME union that organized tens of thousands of workers into action, that has mobilized those members to force Democratic administrations to do things that they wouldn't do in bargaining, in terms of getting wage increases, etc. So Mark Janus is essentially a tool of the right wing. The case was not even originally Mark Janus versus AFSCME Council 31. It was originally billionaire Governor Rauner versus AFSCME Council 31. And Governor Rauner made his whole campaign to become governor based on an attack against AFSCME, saying the public sector unions were too strong, AFSCME was too strong, and he was going to force AFSCME into a weaker position, take them out on the strike, and debilitate the union. And when he got into office, he tried to put that into practice by initiating this lawsuit. When he found out that he didn't have standing to do that, the courts ruled that he didn't have standing, instead of just throwing out the case, they immediately substituted Mark Janus for Governor Rauner. So he's just a figurehead for the billionaire interests that want to weaken the union. And again, Mark Janus's job in particular would have been privatized out to Maximus if Governor Rauner's positions at the bargaining table had been successful. That they would have privatized it out to Maximus. He's gotten $17,000 in negotiated wages through AFSCME during the time he's been there. His health care costs have not doubled as the governor wants to double his health care costs. So he's been the direct beneficiary of the union. And not only has he been the direct beneficiary, but the union itself has struggled and fought and pushed back and successfully in making sure that the full range of that program that he administers for the people there in terms of child support is not diminished, which is one of the things they wanted to do. So this case comes from that that origin, the billionaire governor trying to smash unions in Illinois, and it's sort of symbolizes what else is going around, not only in the other brother mentioned the Rust Belt. Well, the Rust Belt is not what it used to be in terms of being union friendly. Look at Michigan. Look at
Wisconsin.
all the right to work states. Yeah,
Yep.
Wisconsin, Act 10 and right to work. So this is a national problem, a national attack that's symbolized by this case. Is symbolized by all the things that Trump is doing right now. Symbolized by all the other court decisions that the court has just issued in the last couple of weeks. So it's a broad attack. But it's not the death knell. In fact, for many, many decades, public employees didn't have the right to organize a union. Public employees didn't have the right to strike, but yet they struck and they won unions and they won rights and they pushed back and lifted the entire working class on their shoulders, even when it was not legal to do so. So this decision is a harmful decision. It's definitely something that's going to have an impact, but it's not the death knell. And it has already, as Brother Knowlton was pointing out, taken up a number of unions so that they are now all unions in the public sector are much, much more focused on engaging with the membership and making sure that there's a union consciousness among the membership, that union membership is involved and mobilized. That is absolutely the case at AFSCME. I can speak with direct experience about that, about one-on-one conversations with tens of thousands, hundreds of thousands of people, actually, and making sure that we're ready for this decision, as ready as we can be.
Peter Knowlton, in her dissent today, Justice Kagan said something that was very interesting. I wanted to get your comment on. She said public employee unions will lose a secure source of financial support. State and local governments that thought fair share provisions furthered their interests will need to find new ways of managing their workforces. Across the country, the relationships of public employees and employers will alter in both predictable and wholly unexpected ways. What ways might those be? What should we expect to see in relations between public employees and the governments they work for?
Well, it's very possible. I mean, I will remind everybody that after the busting of the air traffic controllers by Reagan in 1980-81, and that struggle, that there became a wholesale assault on workers and on the trade union movement by not only his administration, but subsequent administrations, and created a whole industry called the union bust industry, where professional consultants and lawyers make gazillions of dollars off of the backs of working people over the last 30, almost 40 years. So there's that, but there's also, I know that when Wisconsin was passed, Act 10 was passed in Wisconsin, relations that had been relatively stable and very fruitful between employers and the unions in Wisconsin changed drastically after that decision. And that's in discussions I've had with people who service and who represent workers in Wisconsin, that employers took a very nasty position and had a very nasty edge to their relations with the unions after that law was passed. So I suspect some of that with this, that the relations between the public sector employers and public sector unions will take on a little bit sharper edge, a little bit of a nastier edge. We haven't seen it yet, but today is just the first day of the decision. But I suspect this does sort of give some oats to employers who think that now they can basically do whatever they want to, that the strength of unions has weakened, which it hasn't. It's just merely the funding mechanism has made it a little more difficult for us. But our strength has no less waned, either pre-Janus or post-Janus, organizationally or politically. And unions are pretty savvy. We're all survivors. We'll figure this out. And as I said before, in some ways it may make overall the trade union movement a little bit stronger, a little bit more aggressive, a little bit more militant, which would actually be a very positive thing for workers in the United States.
That's Peter Knowlton, president of United Electrical Workers. We're also on with Jeff Bigelow, who was in Springfield where the Janus case came about, representing workers in AFSCME. Jeff is now in Southern California. I want to go back to Kagan's dissent, Jeff, as well. She writes, today the court succeeds in its 6-year campaign to reverse Abood. Its decision will have large-scale consequences. And then John read the rest of the sort of quote from her. But she also goes on and says, rarely, if ever, has this court overruled a decision, let alone one of this import, with so little regard for the usual principles of what amounts to, in Latin, a precedent, the court's own earlier decisions, in this case, the Abood decision in 1977. There are no special justifications for reversing Abood. It has proved workable. What we're seeing, Jeff, and we can see this, I think, now with the Trump administration, its character has become revealed. It is perhaps the hardest right administration ever. Even if it does something good, like I would say signing a peace treaty possibly with North Korea, which would be good and a welcome thing. When you look at their position towards unions, their position towards immigration, their position towards women's rights, LGBTQ rights, and especially with Gorsuch now on the Supreme Court, they're going for everything the right-wing billionaires have dreamed about. And now we just heard earlier this afternoon that Justice Kennedy, who is a little bit of a swing vote, mainly a right-wing vote in the Supreme Court, is retiring, which means Donald Trump gets to replace Kennedy with another version of Gorsuch. This is a regime of real class war by the employers and by the ultra rich. I mean, do you see it that way?
Yes, absolutely. And that sort of follows what Brother Knowlton was just talking about, the analogy to 1981 and Reagan's destruction of PATCO and the use of the military to essentially accomplish that end. And that opened up a decade or more than a decade, but definitely the most intensive war was in that next decade, 2 decades, with massive wage cuts, contracts being ended, contracting out happening, other things like that, and all throughout the Midwest and reverberating across the country. And there was very, very difficult times. This decision occurs in a different context where the labor movement is even weaker, where only 6.5% of the private sector is organized. The strongest part of the labor movement, the public sector, is affected directly by this, and 33%, 35% of the public sector is organized. So they're aiming this dagger at the financial heart of the strongest part of the labor movement in order to weaken it. And they weaken it so that they can open up the floodgates to all those entities, all those the interests and powers that want to just ride roughshod and have their program not meet any resistance whatsoever. In particular, one of the things that they will be focusing on in the near future, almost certainly, is pensions. They said in California, they said explicitly that they were pulling back on their last initiative to end public sector pensions, defined benefit pensions, a couple of years ago because they wanted to wait until the Friedrichs decision was done, and that was essentially postponed until this decision today. And so they'll be organizing to wipe away those pensions. They'll be organizing to wipe away rights of every kind. And that's, you can see that not only the court decisions regarding the travel ban, regarding the limitation on employees being able to join together collectively to bring legal claims on work-related issues, on women's right to information about abortion, on gay people's right to get cake from a cake shop, on voter purges, on racist gerrymandering, all that type of stuff. It's seen in Trump's attempt to privatize, his stated attempt last week to privatize the Postal Service and the Tennessee Valley Authority and Freddie Mac and all these other things. His executive orders attacking the bargaining rights of the public sector unions in the federal sector with AFSCME. This is a very broad attack right now, very serious attack, and the battle lines are being drawn. It may not be in the headlines and to the extent that some of the other elements of this anti-working class assault is, for example, immigration, but it's very definitely coming after labor rights at every level. So the struggle is on.
Yeah, Peter Knowlton, it's a frontal assault against labor. I mean, there's all kinds of sort of nuanced, or they're not really nuanced, but slightly hidden assaults on labor. This is like the government of the United States, which, at least since 1935, has attempted to appear, at least in some instances, as a mediating force But this is the government itself becoming, as Jeff said, a dagger at the sort of juggler for labor. We've had this phenomena where in right to work states, and that's what we're talking about, Janus making all states right to work states in essence for public sector workers. We've seen the teachers on the march, though, the teachers on the move, in spite of the limitations of dues collection and the fact that they're open shops. We have this new sort of, who would have thought, perhaps the vanguard of a revived labor movement coming from, quote, red states by unions that don't have these kind of advantages. Go ahead. We have about 3 minutes left.
No, I'll be very quickly. I mean, I'm not at all surprised, and we're not at all surprised because we represent a lot of workers in right-to-work states. So we're not at all surprised that at some point workers can only take so much, and then they take whatever action is necessary for them to be heard, and more importantly, to actually deliver the goods.